WAUK.
And join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning. This is Jim Santelle, and yes, indeed, I am your host for this hour and next hour as well here on our Saturday morning broadcast. I am honored. I'm delighted to have each and every one of you with me this morning as we once again pursue some of those most important issues, those news items, those factual developments in the areas of law and government and the aspiration for justice in America. We're coming to you this morning live from the broadcast studios of WAUK The Shaw in downtown Waukesha, but we are broadcasting throughout the broadcast network of civic media throughout the state of Wisconsin. Not only are we live this morning, but this broadcast is also repeated on Sunday mornings, the same time period, perhaps 24 hours dated, but nonetheless hopefully topical and focused upon the issues that you want to hear about. And as always, this morning, we're taking your phone calls, your questions, your comments, your inquiries here on the broadcast. That number is 844-967-2789, 844-967-2789. We already have a couple of callers we're going to get to in this hour to engage with you on those important questions and inquiries on the syllabus, the academic approach of our day. And indeed, as always, we have an ambitious but achievable agenda for this hour and next, always asking, and hopefully always answering as well. Three principal questions. What happened? What do we know about the facts of an event of this past week or weeks or even months? What happened? What are the facts? What are the things that we know for certain? And based upon those facts that we know, why are those things important? Why are they relevant? Why are they significant in understanding the world in which we live, our nation, our community, our neighborhood? And finally, in many instances, not all, but many instances, what do we do about those things? We never tell you how to react, how to respond to them. But if there are appropriate reactions to make, to pursue, actions to undertake on behalf of the things that you have identified in your lives, understanding why they're relevant, what kinds of things are available to you as options as citizens of our community, of our state, and of our nation. What can we do going forward to address those things, the good, the bad, and things in between, to make our world a better place for all of us as a part of a larger community? This morning, as always, we do have that very ambitious but achievable agenda, focusing upon some major news events, and what a week it has been in the area of law and government, and yes, indeed, justice in America. We could not get through the day. In fact, the feature principally of this hour and next is going to be focusing upon those things happening in the courts, principally the federal courts, but not exclusively, the federal courts of our nation. We're going to be spending some time talking about this major oral argument before the United States Supreme Court just this past week, determining whether or not candidate Donald Trump, former President Donald Trump, will remain on the ballot, the Republican primary ballot in the state of Colorado. You have heard all about that during the course of the last several weeks and even months. Major oral argument this past week in a case that is important not only to Colorado, plainly the rest of the nation. I would offer that as significant as that oral argument is. And yes, indeed, we're going to make the very easy prediction this morning, as we have in the past, about what the Supreme Court is going to be doing in respect to the challenge by Donald Trump to his removal from the Colorado ballot. We're going to make that prediction again with almost absolute certainty about what the Supreme Court is going to be doing. In addition to that, however, we're going to talk about two other cases that are arguably even more important. One of them has to do with this immunity issue that's pending right now before the D.C. Court of Appeals. The D.C. Court of Appeals finally, after about a month of deliberation and review of the merits of this challenge by the former president to the criminal prosecution against him pending in the trial court in the District of Columbia, this challenge to that prosecution based upon his belief, his factual argument that he should be immune from any sort of criminal prosecution by virtue of the fact that he was once the president of the United States of America, executive or presidential immunity decided finally this past week by the D.C. Court of Appeals, a 3-judge panel. We'll talk about what those judges said in their sweeping order that made clear, as we have said before in this broadcast, how simple and how frivolous this argument is. They adopted basically that position and said there's no there there. And we're going to talk significantly about what's going to happen next. Something going to happen on Monday in connection with a possible appeal of that decision to where? Yes, indeed, to the United States Supreme Court. We're going to talk about the options that the Supreme Court has. There are 3 in number. Once Donald Trump predictably files his petition for a writ of certiorari this coming Monday, we're going to talk about what the Supreme Court has on its docket then. That's the second matter. And then we're going to also talk once again, as we have talked before, about this major case involving a gentleman named Fisher, Fischer. It has flown wildly under the national radar, under the news headlines of America. But I would offer, as I often do, that this kind of case is among the 3 that is among the most significant cases when it comes to the political environment in which we're presently living, having to do with whether or not a particular statute in the federal criminal code is the proper predicate, the proper basis for charging about 120, even more people who have been charged in the insurrection on January 6th, relevant to Mr. Fisher's case. We'll tell you more about the background of that, how a lower court basically sided with Mr. Fisher. An appeals court, the D.C. Court of Appeals, overturned that decision, now pending before the Supreme Court to decide whether or not the government, the United States Department of Justice, and the U.S. Attorney's Office in the District of Columbia has properly invoked this statute to find that indeed Mr. Fisher's conviction should stand. Relevant, why? Relevant because that statute is also the same one under which Jack Smith, the special counsel, has charged Donald Trump in his own discrete prosecution, also pending there in the District of Columbia, also related to the immunity issue. Lots going on there, lots to unpack there. And again, Fisher, we're going to spend some time chatting about why that among these 3 cases that are pending or may be pending soon for the Supreme Court are going to animate a lot of what we're thinking about this coming year in this political environment. We're also going to be focusing throughout today's broadcast on this continuing notion of time. I believe that during 2024, as significant as the substance and the focus on the content of all these arguments and the political and legal machinations is, as important as all that is, the most significant theme we're going to be hearing about repeatedly is time. What is the timing by which decisions are made, juries return verdicts, cases are indicted, cases are postponed, and indeed the interweaving of that with the political environment and the political schedule that is just now underway as primary elections across the country get underway, including right here in Wisconsin in early April. We're going to spend a lot of time talking about that relationship between timing, things in the courts, and things going on in the political campaign in 2024. Necessarily, we're going to also, as a part of that, be talking a bit today about Eileen Cannon. She is the federal district court judge, not in the District of Columbia, in Florida. She is the one who's presiding over one of the two federal criminal cases pending against Donald Trump. The one being prosecuted by Jack Smith in the District of Columbia, focusing upon the insurrection, the attempt to interfere with the 2020 election results. That is the one that's pending before the judge in the District of Columbia. Her name, Tanya Chutkan. It is her order that's right now being the subject of review by the D.C. Court of Appeals. Eileen Cannon presiding over the other case, also being prosecuted by Jack Smith. This one in Florida, in a district court, a trial court in Florida. This is the Mar-a-Lago documents case, alleging basically, again, in several counts against several defendants, not just Donald Trump, but others involved with him, not only in taking, but also retaining, using, bandying those documents about for public display. All those allegations now in front of a federal district court judge there, Eileen Cannon in Florida. She made some major decisions this past week that are going to have a major impact upon the future of that litigation pending. We're going to talk about a decision she made in connection with some witnesses and the threats right now being bandied about, being hurled in the direction of witnesses who might be a part of that trial. The response by Jack Smith, the special counsel's office, and his objection to what she did in terms of refusing to permit the production of information about those witnesses not to be disclosed in the public domain, not to be provided in the public domain. Why? To protect the integrity of the process, to ensure that those witnesses are indeed safe and secure. We're going to talk about that. We're going to talk about her history as well, even in connection with her past involvement with, yes, the 11th Circuit Court of Appeals. You remember well that she was the judge whose order in connection with the search warrant at Mar-a-Lago went up to the Court of Appeals, the 11th Circuit, and sent back to her with strong instructions that she needs to dismiss this case, that she has no business engaged in the pre-prosecution, the pre-charging review and investigation of that case. She has now got the substantive prosecution in front of her, randomly assigned to her, probably once again going to go up to the 11th Circuit as Jack Smith, quite animated about what she did just this past week in connection with this witness issue. We'll talk all about that. And then finally today, a couple more things in the environment generally. One of them has to do, of course, with the report issued by another special counsel in connection with the documents involving the current president. His name, of course, is Joe Biden, releasing a report this past week that finds, not at all surprisingly, that there is no criminal intent. There was no intent at all, no willfulness, no purposefulness by the present president during the time when he was the vice president and resumed his federal service as the president. No intent in taking with him, holding, and perhaps even storing in his office in Washington, D.C., and also at his home in Delaware, documents that he should not have had. And so determining this past week in this major report from another special counsel that there will be no criminal prosecution. We'll talk about why that's entirely appropriate, given the absence of a willfulness element in this, but also the thing that's animating a lot of discussion in the day or so since the release of that report, that is this finding along the way, contrary, I will offer to you, to the fundamental notions of Department of Justice about what you comment about in connection with the witnesses and those kinds of things that animate the final decision. All of that, and much more this morning on our broadcast. I'm going to encourage you not only to call in, but also to engage with me, even beyond the call-in show this morning, in these important topics, because this morning, we are coming to you in the wake of these major issues in American jurisprudence having to do with all these cases and the campaign as well. When we come back, we're going to talk more about the Supreme Court and all those cases, inviting your participation as well. And we are continuing this morning our discussion of all things Supreme Court and more, beginning right now with this major oral argument that has been on top of the headlines, newspapers and media outlets throughout the nation focusing on this major issue. Again, I'm going to posit the notion that as important as this oral argument has been, it is predictably going to result in placing Donald Trump back on the ballot in Colorado, and that these other cases that are pending before the Supreme Court, or shortly will be pending before the court, are actually the more important ones. But let's take up that case, that oral argument pending in front of the Supreme Court just this past week. Where does this come from? We have spent a lot of time. You know it well now, right? This is the 14th Amendment, Section 3, that basically says that if you've taken an oath of office to serve the government, and you subsequently engage in insurrection or rebellion against the same, you are not entitled to continued or renewed government service. That is my articulation of a much more appropriately constitutional language in the Constitution itself. That is the section that Colorado was recently wrestling with, including a lower court judge that had a trial on whether or not Donald Trump had, number one, engaged in insurrection on January 6th, and second, whether or not that particular language of the Constitution, Section 3, 14th Amendment, applies to him as the president. The lower court finding, as you may recall, that yes, indeed, there was an insurrection, that yes, indeed, Donald Trump took part in that insurrection and even was a major author and animator of it, but found in the end that because of the language of the section of the 14th Amendment that talked about officers, that Donald Trump is not an officer. He was a president, but not an officer, kind of a head scratcher for many of us out there. And indeed, the Colorado Supreme Court taking that up then, this is the state Supreme Court, found not only that Donald Trump had engaged in this insurrection, but that the 14th Amendment does apply to him and threw him off the ballot, threw him off the Republican primary ballot coming up here on Super Tuesday. That's the case. That's the case that then went up upon Donald Trump's petition, a writ of certiorari, that is this request to the Supreme Court to hear the lower court. We know under the Constitution that's one of the bases upon which you can get to the Supreme Court, which is if there is a decision of the highest court of a state, that in fact can be appealed to the United States Supreme Court. Indeed, they granted that request, that petition for writ of certiorari, and they heard that oral argument just this past week, a major argument. The upshot of it, the headline, which you have also seen, unmistakably, the Supreme Court is going to put Donald Trump back on the ballot in Colorado. We have predicted that before on this broadcast and other broadcasts of Civic Media. Not a surprise, given the merits of this case, although I want to hasten to add this, that if you read the Colorado Supreme Court, again, a magnum opus, reviewing in great detail the trial court's decision, you will be compelled. And in a world perhaps of perfect facts and perfect justice and perfect legality, you would be convinced, I believe, that yes, there was an insurrection, that yes, indeed, the language of the 14th Amendment applies to this, and that the Colorado Supreme Court got it right on the pure merits of this. In that kind of perfect world, that order, that decision that I commend to you for reading is compelling reading. Regrettably, that decision, that assessment, if you will, by me, is not the one that's necessarily going to dictate how the Supreme Court resolves this. And indeed, it appeared that virtually all 9 justices, in ways great and small, just this past week, during the course of this oral argument, were likely, presumably almost certain to reject this challenge to Donald Trump's eligibility to serve on the ballot coming up here based upon the January 6th event. The Supreme Court, in several hours of discussion with the attorneys for the Colorado petitioners, these are the folks who petitioned initially to keep Donald Trump off the ballot, and the attorneys for Donald Trump, who are seeking to have him replaced, returned to that ballot, put back on that ballot. A huge amount of fascinating oral argument between the attorneys and the members of the Supreme Court. Some justices obviously seizing on different events. Interestingly, very little of this long discussion focusing upon the central issue that I suspect much of us would be focused upon, as is the order coming out of Colorado, which is whether or not this insurrection happened and whether Donald Trump participated in it. That particular issue is not really the subject of a lot of focus by the justices of the Supreme Court. That is the issue of insurrection itself. A little bit on that. We'll get to that from John Roberts, and also the former president's participation in that. But a lot of issues we've been calling off-ramps, if you will, a lot of procedural issues, a lot of issues about the consequences of the Supreme Court keeping Donald Trump off that ballot. And indeed, in the end, my own sense, my tea leaves reading from that oral argument, that probably the majority of the Supreme Court will make the decision to put him back on that ballot just because of the concern about having this patchwork of states out there, some of which may indeed have Donald Trump on the ballot, some of which will not. That was articulated by more than a few of the justices as well. Some also seemed open to 2 other arguments. That is that the post-Civil War prohibition, which is in the 14th Amendment, that bars candidates from holding office, as we said, as opposed to running for it. And that those are two different things, holding office and running for it, the kind of argument that perhaps only lawyers can love. And that the president, as the lower court found in Colorado, the president is not among the officials to whom that provision specifically applies. John Roberts, the Chief Justice, I just mentioned him, asked a series of questions reflecting what seemed to be this emerging consensus, once again, probably coming out of an opinion fairly shortly, that the 14th Amendment was not meant to permit individual states like Colorado. We know that Maine is also arguing about this issue. Right now, the Maine decision on hold while this Colorado opinion is resolved. The 14th Amendment not meant to permit individual states to determine whether a candidate was ineligible. And again, not only based upon the inconsistencies then from state to state, but also this notion that there should be review by a federal authority and not a particular state. The whole point of the 14th Amendment was to restrict state power. And that's the question that John Roberts asked the attorneys, adding that the challenger's contrary argument was, as he said, a position that is at war with the whole thrust of the 14th Amendment. That is a justice who's plainly not buying into the position of the Colorado petitioners keeping Donald Trump off. Justice Roberts noted that the position that they were advancing would have empowered the former Confederate states to determine whether candidates were disqualified from holding federal office. He's going back to history, which again was the subject of a lot of the argument back and forth, including argument from Ketanji Brown Jackson and some of the lawyers as well. The 14th Amendment was adopted to constrain states' rights and empower the federal government, the Chief Justice says. And it would be, as he said, the last place that you'd look for authorization for the states, including the Confederate states, to enforce, implicitly authorized to enforce, the presidential election process. That, once again, from a Chief Justice, one of the 9 votes that plainly is going to return Donald Trump to that ballot. Justice Elena Kagan also had some significant things to say. And when we come back, we're going to talk more about Justice Kagan and Ketanji Brown Jackson and Brett Kavanaugh and all of the others just this past week. Related, including comments made by the justices of the Supreme Court in connection with this major oral argument before the court just this past week. Plainly, unmistakably, the Chief Justice John Roberts coming down on the side of the federal government, saying the states should not be able to direct a national election of this sort. He was joined by that view in the statements made by virtually every other justice who was also part of the questioning. Brett Kavanaugh reviewed what he said was the relevant history and concluded in his words that Congress has the authority here, not the states. He specifically said that the challenger's position that Mr. Trump may not be on the ballot, as he was describing it, was in tension with democratic principles, especially given the provisions indeterminate quality. Now, what does he mean by that? He went on to say this. He said, in trying to figure out what Section 3 means and the kind of extent of its exclusive language or vague language, what about the idea that we should think about democracy? Think about the right of the people to elect candidates of their choice, of letting the people decide, because your position, he said, has the effect of disenfranchising voters to a significant degree. He's directing that position statement, of course, to the people who want to keep Donald Trump off of the ballot in Colorado. Interestingly, the Chief Justice, Brett Kavanaugh, others, joined by others on the other side, if you will, of the political aisle, Justice Elena Kagan also expressing concern about granting individual states way too much power over, as we've described them, the national elections. She said this. She said, I think that the question you have to confront is why a single state should decide who gets to be president of the United States of America. Again, scratching her head, she said, why should a single state have the ability to make this determination, not only for their own citizens, but also for the rest of the nation? And yes, indeed, Ketanji Brown Jackson, the junior, the sophomore, the freshman member, if you will, of the Supreme Court, said she doubted that the drafters of Section 3 intended to create, as she called, disuniformity in this way, where we have elections pending and different states suddenly saying, you're eligible and you're not. And indeed, in connection with this general issue of insurrection, the Chief Justice went back to some of that issue and raised the concern about the definition of insurrection generally. He said insurrection is a broad term, and if there's some doubt about it, he said, I suppose that will go into the decision and then eventually would be deciding whether it was an insurrection when one president did something as opposed to when somebody else does something else. And what do we do? Do we wait until near the time of counting ballots and sort of go through which states are valid and which states aren't? He said that was a recipe for chaos. That language actually is somewhat troubling, somewhat reminiscent of what Donald Trump himself is saying on the campaign trail. Undeniably, however, a part of this overall voice coming from probably virtually all the members of the Supreme Court is going to return back and say to the folks from Colorado, no, you got to put Donald Trump back on the ballot. The Chief Justice saying for the Republican candidate, you're off the ballot. For the Democratic candidate, you're on the ballot. And it will come down to just a handful of states that are going to decide the presidential election. He said that's a pretty daunting consequence. My own sense, again, the sense of anybody who was listening to that oral argument, the Supreme Court is going to overturn the Colorado Supreme Court. Donald Trump is going to get a win, if you will, on this particular issue, not others coming up, but on this particular issue. Entirely possible along the way that the Supreme Court is going to come to a common judgment overturning what the Colorado Supreme Court has done, but maybe getting there in different ways. As I said, there are different off-ramps here, some procedural issues they could raise, and it may well be that we're going to get an opinion very soon in which all of them agree on the result, but come there in a different way, and so we're going to get what are called concurring, agreeing opinions, everybody, or at least two or three of them, or maybe four or five of them writing together, but all of them in the end finding the Colorado decision needs to be overturned. Donald Trump goes back on the ballot. We don't know for certain, of course, until that day that the Supreme Court issues that opinion. This one can't wait. This one can't wait until May or June. Again, the theory of the entire year, the theory of our discussion this morning, tick-tock. Time is important. This is one of those situations where the Supreme Court now has this case under advisement. It could issue its opinion any time now. Unlikely it's going to be Monday, but it should resolve this issue promptly, because once again, Super Tuesday coming up for Colorado and many other states in this nation. At that time, people in Colorado and frankly around the country need to know who's on the ballot and who isn't, including back in Maine, where again, the Secretary of State's position that he should get off the ballot was suspended by the Supreme Court in that state, pending the result of the case Trump versus Anderson. That's the one coming out of the state of Colorado. We will see what the Supreme Court does. And as always, we appreciate so much perspectives, insights, questions from our wonderful, insightful, animated listeners. And we're going to get to those right now. Thank you so much for waiting as we get through this first major issue on our docket this morning. Susan from Brookfield. Susan, thanks so much for being with me this morning.
Good morning, Jim.
Good to have you with me, Susan.
Yeah, I have I'm a little off topic, or perhaps a little bit late on my question, but I had recalled that shortly after the election, they had changed the rules in how they calculate the counting and everything for the ballots. I was looking to see if I could find out just what it was that they had done, because I was unsuccessful at that. I thought you might have some recollection of that. The second thing about that is that we will be having a Democrat being the person who's in charge of counting the election for the next election. And I'm just wondering at this point, what else are they going to be able to try to pull? Because there are a lot of the things that they seem to have focused on, like the electors being illegal electors and stuff like that. That's kind of been cut off as an avenue for them getting their own way. And so I'm curious as to what people may think are the likely ways that and I do believe that Trump is going to lose the electoral vote, but we all know he's going to try to pull something. So
right.
I'm just interested. You might have any thoughts on the matter.
Absolutely. Susan, great thoughts and great speculation. That's what this year is all about, too. What's going to happen? We don't have a crystal ball. I certainly don't. I suspect your perspectives are even better than mine are. But yeah, a couple of things pulling out of that, plainly in the wake of the debacle, which was January 6th, restored again by not only Nancy Pelosi, but Mike Pence together. We recall them very well late in the night, still insisting on going back to count those ballots. In the wake of that, legislation did pass, and I think that's what you're making reference to ensure that some of the counting is clarified so the next time around, those kinds of things in their minutia and in broad issues generally are not quite as confusing as they were before. More centrally, your other issue having to do what other options are out there. We do have two different players now coming up, presumably next January when the electoral votes are counted, and they are plainly the vice president, and her name is obviously our present vice president, and she is going to be counting those ballots on a regular basis during the course of that process with the present Speaker of the House of Representatives, and his name, of course, is Mike Johnson. And so the two of them, one Republican, one Democrat, obviously they're in front of the entire Congress on that day, will then, again, as they did before, open up those ballots, open up those electoral votes. Now, one of the issues, of course, is all sorts of constitutional provisions out there about what happens if indeed neither one of them gets the necessary majority. And there you've got all kinds of constitutional provisions that have to do with the constitution of particular delegations from the states and how those are counted. That is an option. All sorts of things could in fact happen during the course of that proceeding. And again, creativity is not in low supply these days when it comes to machinations, but we will have plainly two different players. But again, a Republican and a Democrat. One would hope, Susan, to your good point, that there would be an understanding about the legitimacy of the voting process. But those kinds of things we'll have to wait and see as January comes around. Lots of different things out there. You would like to think in connection with your reference to the fake electors. We know now that there are at least 3 states, the attorneys general, at least 3 states have begun to prosecute those people who attempted to affect the kinds of things, the votes that were in front of Nancy Pelosi, in front of Mike Pence on that particular day. We'd like to think that that particular scheme will not work anymore, but one never knows. And that kind of initiative, if you will, to put it in a positive sense, but really a dark initiative to attempt to codify in ways that are not reflective of what the votes are out there. That's the kind of thing that has to be pushed back against. This is all about, Susan, I think it is in underlying your principal focus here. This is all about ensuring that the votes of America, the votes of citizens out there in all the states, including Wisconsin, are properly counted, that there is legitimacy to them. We know beyond that, the last comment I would make about this, even in the midst of some of the machinations, some of the invocations, Susan, that you talk about, we know in the end that the notion of voter fraud, that is the notion that people are voting illegally, improperly, that simply doesn't exist in America. And if anything, we're moving toward an even tighter system. And so the question is not so much what the numbers show. The question will be, are there attempts, as you indicated, Susan, to pull things, in your words, that are not consistent with what the voters want to do? And so we'll think about that and look at that as that plays out in the coming year, certainly as electoral votes begin to be amassed in the immediate aftermath of the November election. The electors, again, generally getting together in December following the general election. Susan, thank you so much for your comment and your inquiry about what other things might happen down the road here in our system. Also, we have on the line this morning Adrian from Madison. Adrian, thanks for waiting. Thanks for your call, your comment, your question this morning.
Good morning. Now, it seems pretty clear to me that Trump is not really eligible to hold office again based on the 14th Amendment and his actions in fomenting a violent insurrection on January 6th. But it also seems clear that the justices don't want to be in the position of deciding the election or having the courts really involved in deciding the election. They want the voters to decide the election. So they're looking for any way possible to avoid making a decision that, in essence, decides the election in this case. But the thing that I'd like to know, and that drives me crazy, keeps me awake at night, is why couldn't the justices have taken that kind of hands-off approach in year 2000 and saved us the historical debacle of the W. Bush presidency.
Right. Bush versus Gore, 2000, exactly. That's what flashed into my mind, Adrian, as you were talking about this. At that time, a Supreme Court not at all afraid to not just wander in, but jump headfirst into the political environment of that particular time and basically directed that the counting in the state of Florida stop, right? We know in the wake of all of that, based upon history and the actual math there, that Al Gore won Florida by about 600 votes. It was razor thin, but he actually did win that state, should have gotten those electoral votes, but because of a decision, Bush versus Gore, interestingly, the Supreme Court, in the course of its language in that case, also says that this particular case has no precedential value. Nothing about this case should be used in the future, basically saying we're making this one decision and it has no compelling, lasting purpose down the road. But that's the kind of thing, again, the inconsistency some 24 years ago between what the Supreme Court did then and what it appears to be doing now. And there is this doctrine out there called the political questions doctrine. It sometimes invokes and says, you know what, we shouldn't be involved in the federal government with these kinds of political issues. They do that a lot in the gerrymandering area and other areas of life in our nation. Political questions doctrine sometimes gives them some cover. Here, once again, at a minimum, as you're indicating, Adrian, there seems to be some huge inconsistency. They're back in 2020 finding that indeed we can do nothing short of basically determining who the next president is going to be. Here, probably finding that Donald Trump remains on the ballot and, if not vacating the field, not addressing, as you said, Adrian, the fundamental question, which is insurrection, Donald Trump's participation in it, that they're coming nowhere near, and we'll see. We'll see what they do in the opinion coming out fairly soon. Also have on the line right now a number of other callers. I'm going to take them right after this coming break. But right now we're going to be going to a number of different issues having to do with this issue of eligibility on the ballot coming out of the Colorado case. We're also going to talk in the future comments here on our Saturday morning broadcast about this D.C. Circuit case, also much in the news. And then finally, Fisher versus the United States. All of that coming up, along with you and callers more on our morning broadcast. And we are discussing this morning all things Supreme Court, engaging in some wonderful discussion with callers. We've already spoken with Susan this morning, who raised concerns about what happens next when we have our Vice President Kamala Harris and our Speaker of the House, Mike Johnson, counting the electoral votes, presumably next January. And that coming, of course, in the wake of the November election and the electors meeting. What other things can happen to the Constitution? Indeed, I pose the possibility that if neither of the major candidates gets a required number of electoral votes, goes back into the House. And the process there for counting by state delegations, that's an option. That's actually not an undermining of the process. That's the way the Constitution is set up. But Susan raising concerns about other things that we have seen in the past electoral process, the electoral cycle, that would suggest attempts to undermine the very counting, the voting process, legitimacy of those electoral votes, things we will continue to monitor as Kamala Harris and Mike Johnson, coming up in about less than a year from now, are doing that all-important constitutional duty. Adrian, talking about the inconsistency between what the Supreme Court appears to be doing now, that is not getting involved in undermining, upsetting in any way the course of the electoral process in connection with the Colorado ballot, and what it did back in 2000, Bush versus Gore, effectively determining that voting should stop and the presidency granted to George Bush at that time. Great callers, great inquiries, great perspectives to share. More of that right now. We've got Kurt calling in. Kurt, glad to have you with me on this morning program.
Good morning. I apologize if someone already asked this question, but wasn't it Alito that asked, why should one state be allowed to determine?
Yes, absolutely. Sam Alito, right, articulating what frankly, many other justices also articulated in ways more articulate and even less articulate, basically saying, why is it that Colorado basically dictates what happens to the entire nation, if you will? Because plainly, if the Supreme Court undeniably says, unequivocally says, that Donald Trump can be off the ballot, we know that there are 25, maybe 30 other states out there, not just Maine, that are also looking at this same issue, and it could create this patchwork. And also, as Justice Kavanaugh said, Justice Sotomayor said, others said from the bench, this notion that this is a state question as opposed to a federal question. The Chief Justice, once again, going back to the time after the Civil War when it was a determination made by the federal government, not the state government, about who is and who is not an insurrectionist and who should and should not be in government. But it was Sam Alito, among the others that we articulated this morning, who share that concern. My guess is between this state focus and the concern about confusion, the chaos that the Chief Justice described, that's probably the basis upon which most of them, if not all of them, are going to put him back on the ballot. Great comment, great observation, Kurt. Good. We also have with us this morning, Kristen from Waukesha. Glad to have you with me again this morning as well.
Good morning, Jim.
Good morning.
I can, as aggravating as it was to listen to the oral arguments, I can almost understand how if they would say, one state can kick someone off the ballot, then I can see other states ginning up reasons to kick other candidates off the ballot, and we'd have chaos.
Right.
However, one of the things that really bothered me was the way they twisted themselves, I think, into pretzels, trying to figure out how they could claim that the president is not an officer of the United States.
Right.
I mean, I just find that to be so ridiculous. Everybody knows that when you're looking at, say, a corporate board of directors, the president is an officer of the board. Of course he is.
Right.
So my question is, if they actually come out, A, can they make this pronouncement without getting into that? And B, if they do somehow state the president is not an officer of the United States government, how many other places is that written and assumed and might, throw off a whole bunch of other laws and parts of the Constitution if the president suddenly is just this amorphous blob, I guess.
Right.
It's just ridiculous to me.
Happens to occupy the big White House down the street at 16th in Pennsylvania, right? But not really an officer, not really an office, and
come on,
right?
I
Absolutely, and I agree with you. Again, it was a fascinating argument to listen to, right? But along the way, I agree with you. When it comes to that, I suspect that the justices just wanted to check off the box all the various arguments, and I hope, like you, that this was one of them. There was this amazing exchange between Justice Gorsuch and the attorneys about this very issue, going back and forth about what an office is and what an officer is, and again, the kind of thing that maybe, again, only lawyers, maybe Supreme Court justices enjoy doing. You would hope that that's not the premise for their ultimate argument, and maybe at most it gets a footnote, in the final decision. I'm hoping that, again, it's a broader issue and that they not even raise that. Because as you just indicated, these things, what the Supreme Court says, you know this well, Kristen, what the Supreme Court does has an impact upon other matters. If they find that the presidency is not, the president is not an officer all kinds of other things become implicated in that, not only in terms of responsibilities under the Constitution, but statutory authorities, all kinds of things out there. I suspect they know that. I'm hoping that Justice Gorsuch and the others were playing around with this issue, simply wanted to indicate, well, we've taken a look at that. And of course, courts can also say, we've looked at this. We're not deciding this today. But we are deciding it on this other issue. And you're right. Then they don't have to engage in the pretzel making that you just described and come up with a decision that has these implications far beyond Colorado and the national election coming up here. We're going to talk more about the national election and other things pending before the Supreme Court in this coming up, our second hour here in our Saturday morning broadcast. So appreciate all the good comments and questions from our callers. Do more of that in our second hour, and we will continue our discussion of all things justice, rule of law in America.
Weekday mornings from 8 till 10 on The Shaw, 540 AM and 101.1 FM WAUK.
Welcome to this, our second hour of our Saturday morning broadcast, talking all things Supreme Court and some other courts as well, but right now focusing a lot on what our United States Supreme Court entertained this past week in connection with the Colorado case. Strong prediction, an easy prediction, if you will, that they will hand Donald Trump, if you will, a win in connection with his attempt to remain on the Colorado ballot, obviously having an impact, as our callers indicated, on the future of this campaign in the next few months or so, and on other ballots around the nation, including Maine and other states. Another major event headed toward the Supreme Court, maybe or maybe not. Coming out of the D.C. Court of Appeals, we're going to spend some time in the first segments of this hour talking about this major case having to do with, yes, that's right, executive immunity. You know what this case is all about. The president maintaining, again, this is outside of the political process, but plainly having an impact upon it and impacting the campaign itself, that in connection with the criminal prosecution of him by Jack Smith, special counsel, Department of Justice, 4 counts alleging his involvement in an effort to undermine, to overthrow, to engage in interference in the 2020 election. 4 counts, that case pending before Tanya Chutkan, in front of the district court there in the District of Columbia. She had previously written an omnibus order addressing all kinds of issues, saying that indeed Donald Trump does not have immunity. He is not immune from criminal prosecution. No one is above the law. She notably said that we have presidents in this nation. We do not have kings. That case went up to the Court of Appeals, the D.C. Court of Appeals, the next highest court in that particular part of our nation. And indeed, just this past week on Tuesday, a couple of days before the oral argument on the Colorado case, down the street there, the D.C. Court of Appeals in another courthouse there in Washington, D.C., turns back and says, indeed, Donald Trump does not have presidential immunity, and without saying it out loud, says that the concept is absurd, that this is a near frivolous argument. Donald Trump on Wednesday being told by the Court of Appeals, a three-judge panel made up of 3 judges, including Karen Henderson, who is a Republican appointee, who has sided with Donald Trump on many other cases. All 3 of them unequivocally, unanimously say nothing to this notion of immunity by a president. Says this: we cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. That's what the 3-judge panel wrote and released just this past week. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. 57-page opinion, all three members of the panel coming to that conclusion. Obviously, a major decision by the Court of Appeals. Spending about a month putting that all together. And now along the way, the Court of Appeals, in addition to making those very important determinations, gives Donald Trump something of a deadline. Says if you want to appeal this, you need to go to the Supreme Court by Monday. Yes, that's this coming Monday. Basically appearing to acknowledge that he is going to be going in that direction, but discouraging him from asking the full appeals court to intervene, probably not going to be granted what's called an en banc hearing, all the judges of the D.C. Court of Appeals deciding this. And that, of course, would further drag out these proceedings. Along the way, the panel of the three judges says, for the purpose of this criminal case, former President Trump has become Citizen Trump. That language, again, much bandied about in the media these days, with all the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. Basically, the Court of Appeals saying, we're not deciding expressly, although certainly indicating very strongly that a president does not have immunity while in office. But today, Citizen Trump has no immunity whatsoever. Along the way, again, addressing a number of different issues, talking about this notion that somehow the separation of powers under that concept, the judicial branch lacks authority to review a president's use of executive power. This argument being made by Donald Trump. They reject that. They say former President Trump lacked any lawful discretionary authority to defy federal criminal law, and he is answerable in court for his conduct. Another affirmation of this notion that we have presidents, not kings. Second, Donald Trump had argued that there is a public interest for the presidents of our nation to be immune from prosecution. Society said better off if presidents don't have to be afraid of future charges, could chill their constitutional authorities and functions. The Court of Appeals say nope. Supreme Court has disallowed, they said, civil lawsuits against presidents over their official actions, but there are far greater limitations to bringing criminal charges. And they went on to say, so the risk that former presidents will be unduly harassed by meritless federal criminal prosecutions appears very slight. They made reference to the fact that Gerald Ford had pardoned Richard Nixon after Watergate, all of that suggesting that there is the possibility of criminal prosecution, long understood in the history of our nation. Former President Trump's alleged conduct, they said, conflicts with his constitutional mandate to enforce the laws governing the process of electing the new president, the three judges wrote. The criminal charges against him, they said, if proven true, amount to an unprecedented assault on the structure of our government, offering a little bit of insight into how they view the charges and the compelling nature of the charges pending against him right now. They went on to say this, that in response to Donald Trump's assertion that former presidents can't be prosecuted unless they're first impeached and convicted by the Congress. They said that's ridiculous. That's not at all a part of what our Constitution envisions. Repudiating that argument, saying the interpretation runs counter to the text, the structure, and the purpose of the impeachment judgment clause. The impeachment and criminal justice systems operate on separate tracks, they said, with separate purposes. And that interpretation implies that all civil officers, not just presidents, are immune from prosecution over official crimes unless they are first convicted in a Senate impeachment trial. That, they said, that notion is ridiculous. It would leave a president free to commit all manner of crimes with impunity so long as he is not impeached and convicted by the Congress, rejecting that outright. And finally, responding equally strongly to Donald Trump's contention that because he was acquitted in the Senate impeachment proceeding, that therefore it would be a violation of double jeopardy to have him prosecuted in Tanya Chutkan's court again. The Court of Appeals saying ridiculous, absurd, that the processes are unrelated. And while the charge the House brought against him, the incitement charge, was not among the charges a grand jury now indicted him on, getting into a little bit of the double jeopardy analysis. Judges also gestured to the political nature of the acquittal, noting that 30 senators had justified their votes to acquit him when this was in front of them on the grounds that his term in office had run out before the trial. And they said this, as a result of the political nature of impeachment proceedings, impeachment acquittals are often unrelated to, here we go, factual factual innocence. Impeachment acquittals are often unrelated to factual innocence. All of that from the Court of Appeals just this past week, an unequivocal statement rejecting Donald Trump's position on immunity. As I've said before, this is a frivolous argument. This is an argument that has no merit to it. It is regrettable that we are spending all of this time announcing that the sun rises in the east and not in the west. That's how absurd this proposition is. And yet, the district court obliged to address it as she did. The Court of Appeals now saying the same thing in an equally broad and expansive opinion, providing a huge amount of support, addressing all the issues that Donald Trump raised and putting them all to bed. And so, what is the big takeaway? What is the big takeaway from what happened this past week coming out of the D.C. Court of Appeals? It's just this. Once again, our theme this morning, our theme throughout this year is all about timing. Tick-tock. What's going on with the clock? Well, as I said, the Supreme Court plainly, as before it, this one case involving Colorado. It will decide that fairly soon, presumably before Super Tuesday. It's got another case we're going to talk about in just a minute or so involving Fisher. It's probably the most significant among the three. But it potentially, as soon as next week, could have this second case, this D.C. case before it as well. It depends upon what the Supreme Court does. Now, Donald Trump has signaled that he's going to meet the deadline established by the Court of Appeals, and yes, indeed, is going to appeal to the Supreme Court, this writ of certiorari, which we often talk about. And the Supreme Court then, effective Monday, close of business, will have a decision to make. Actually, can do one of two or three things. One is they can deny that writ. They can say, you know what, we're not going to be resolving this at all, as they do routinely. Right now, as of this morning, there are 60 cases on the docket of the Supreme Court. Hundreds more have been subject to a denial of writ. You don't get before the Supreme Court just by filing your papers. They could say, you know what, we're not going to review further this matter that the D.C. Circuit Court has addressed, the trial court has addressed. These omnibus opinions are clear. We don't need to say anything more about it. And indeed, I would offer that in a world, again, of perfect justice and perfect jurisprudence, that's what they should do. There's no conflict about this. Nothing here more to be said, aside from perhaps putting your imprimatur upon what the lower courts have already said. That is what they should do. Now, the question is, what will they do? That's a different question. And it's entirely possible that if you've got a majority of the Supreme Court justices who nonetheless want to be heard about this, they regard this maybe as their own version of Bush versus Gore. We talked about that before. Maybe their own version of the Colorado case, and they want to be heard about this and want to establish once again, as the Supreme Court has done before, that indeed presidents are not kings. No one is above the law. They can take this case and they can do one of two things, both of which would be telling about their particular animation. One is they could take the case and they could say, and although we're going to take this on, we recognize that the entire prosecution in front of Judge Chutkan down the street in the district court has been suspended. She has taken this trial off her calendar. Going to be requiring months of jury selection and of actual trial time. She's taken that off her calendar. The Supreme Court could very well say we need to get this expedited. And so, while we're going to grant the writ, we're going to give you an expedited disposition of this. You file your brief within 5 days. Government, you respond to that within 5 days after that. We're going to schedule oral argument expeditiously as well. And we're going to resolve this very, very quickly. Even with that, we're probably talking about another month over and beyond Monday before the Supreme Court could enter an order, again, affirming almost certainly what the lower courts have said to this point. And there's a third option out there for the Supreme Court, which is perhaps the most disappointing, which we also need to put on the table this morning. And that has to do with putting this on the regular docket. That discussion about a regular docket is coming up next. This morning of all things Supreme Court, talking about the options before the Supreme Court as it now has not yet on its docket, but plainly a petition coming on Monday. Close of business Monday. Donald Trump and his attorneys will be filing this application for a writ of certiorari seeking another level of review before the Supreme Court in a case that, again, has clarity in its ultimate disposition. There is no question but for the fact that the lower court, the district court, the appeals court have gotten this right. Presidents do not have immunity. And if indeed any court in this land, including the Supreme Court, should find otherwise, that is the beginning of the end of the republic because, as many people have said, then we're restoring the monarchy. Then we do, in fact, have a presidency that is without checks and balances. If a president can do whatever he or she wants to do, we have then returned to a pre-1776 period in our nation's history. Can't do it. Not a possibility. So the result here, once again, just like right now the Colorado case is resolved effectively. We haven't seen the paper on that yet. This case is also not subject to reasonable disagreement here. Everybody of a reasonable nature acknowledges that there's no presidential immunity. And what is going on here, of course, is a delay in the trial in front of Judge Chutkan. And that's why what the Supreme Court does next, presumably as soon as next week, is all telling about their particular animation as they work indeed in the midst of a campaign in 2024. As I said right before our discussion suspended here for just a moment, before the Supreme Court decides what it's got to do, it can turn back this appeal, can deny the request outright, in which case Tanya Chutkan, the day after they deny that grant, that writ of certiorari, she can call the parties in and put this thing back on her calendar. She can find the trial time to do it. It's a lot of time, but she can get them back in, have a status conference, a pretrial conference, and get this back on her calendar the moment the Supreme Court denies Donald Trump's application. More likely, potentially, the Supreme Court says, well, we'd like to weigh in on this. It is a matter of national importance, and I suppose it is, but for the fact that the issue is preordained. We know what the result has to be here, and so it is frustrating, I think, for an awful lot of us out here who think about the legitimacy of the process, to think that the Supreme Court now needs to weigh in. And yes, we understand the Supreme Court wants to articulate once again, hopefully, what would be a unanimous position that there is not a presidency that is in the nature of a kingdom, a situation where we've returned to the monarchy in our nation. If the Supreme Court does that, they could put this on a very expedited schedule. Even that, however, taking probably days, weeks, presumably postponing the ultimate rescheduling of this matter in front of Judge Chutkan by about a month. And every single month, of course, in this calendar year takes up more time, delays the time when Judge Chutkan can begin to impanel a jury. That will itself take a number of weeks right there in the District of Columbia. Presumably, the presentation by the special counsel is going to take weeks. Donald Trump does not have to present any defense, but presumably would. And that could also take days, if not weeks, before a jury then gets the case to deliberate on, presumably months down the road. And that, of course, begins only after this issue of immunity, this frivolous issue of immunity, is resolved ultimately by a court. Supreme Court could do it, quite literally, hours after the petition for writ of certiorari is filed on Monday. Will they do that? We will see. If in fact they put this on what is the regular docket, and they accept certiorari, just as they have with all of the other 60 cases as of this morning on the docket of the Supreme Court, if they do that, they could also establish a routine briefing schedule. If they do that, they have signaled their own sense of urgency, which is very little in that particular circumstance, because there you've got weeks before petitioners file briefs, you've got responsive briefs, you've got reply briefs, all these kinds of things. There will probably be amicus briefs filed by various parties around the country. All of that, as in all these other cases, takes time. And then if indeed we get a decision along with all the other cases we've talked about on this broadcast in the areas of social media and about guns and about all the other things that we have discussed along the way in our broadcast to this point, last year and this year, if that is on the regular docket, the regular schedule that does not contemplate an expedited resolution along the way, then we can anticipate a decision in June, maybe May, but in June. And at that point, you have profoundly affected the trial calendar. At that point, Judge Chutkan may have great difficulty in finding a time on her very busy docket. Remember, this is not the only case that she and her colleagues at the district court, the trial court level, have on their dockets. then it is entirely possible that there will be no trial before the November election, or if there is, it will be just on the heels of that significant event happening. Tick-tock, time once again, an animating feature of 2024, and in all of these, the interplay between the litigation, the criminal prosecution, the civil cases we've talked about as well, and the pendency of things like Super Tuesday, the people going to the polls here in the state of Wisconsin and in other places around the country, Colorado, all the other states, primary elections coming up, all those kinds of things. A convention coming up in Milwaukee for the Republicans in July, for the Democrats in Chicago right after that in August, and then the final weeks into the election. All of these kinds of things animated by time in and out of our federal courts, criminal courts, and civil courts as well. Look next week to see what the Supreme Court does. They're not obliged. They're not on a particular schedule to decide whether to grant this writ of certiorari or not, but they need to do it. They need to tell the American public what they are doing and with what level of speed are they going to address this. They can take care of it very quickly, or they can, at the other extreme, put this on the regular docket and schedule this, presumably for the announcement of an opinion, the substance of which we all know, and that is that there is no immunity and that presidents are not kings, as Tanya Chutkan has said. That's the second case. And again, the reality is that as much as Donald Trump may be granted a win on the Colorado matter, he will be granted ultimately a loss on this issue related to immunity. There is no there. There's nothing to see here. The question is, when will the Supreme Court issue that opinion? And then, as we have talked before, there is yet a third case that does not have Donald Trump's name on it. But I would offer, as I have before, that this case involving Fisher, Fischer, Joseph Fisher is his name, is among the three, the ones that's the least clear in terms of his disposition, and arguably because it's least clear, also has the most profound effect potentially upon that criminal case being prosecuted right now by Jack Smith and special counsel in front of Tanya Chutkan in the D.C. Circuit. Why? Because of what Joseph Fisher is, what he has petitioned for, what he has done. The man who brings that appeal, again, his name, Joseph Fisher, has said that the law was applied against him incorrectly and that the charges against him have to be overturned by the Supreme Court. On recent days, in mid-December or so, this particular matter was granted cert by the Supreme Court, and the discussion continues this morning about what the content of that appeal is all about, why it is significant for hundreds of people already charged and convicted for the assault on our Capitol, and yes, indeed, why it is so critically important for understanding what Tanya Chutkan will and will not have in front of her when that case ultimately goes to trial, the criminal trial in her court against Donald Trump. We are talking this morning in these final segments of our 2-hour broadcast about Supreme Court cases. Another case, a third case, not often discussed in the national media, not the subject of a lot of attention out there, called United States versus Fisher. United States versus Fisher. Back in December, mid-December, the justices of the Supreme Court granted a writ of certiorari, said, yes, indeed, we're going to take this case on. It decided to review the charge of obstruction of an official proceeding that was brought against Mr. Fisher. Mr. Fisher, among the thousands of people there on Capitol Hill that day, among the 1,200 or so who've been the subject of investigations and charges and convictions and sentencings, including among them Joseph Fisher. Joseph Fisher, again, charged with this particular statute in the Federal Criminal Code, a charge of obstruction of an official proceeding. Significantly, 300 people altogether have been charged with this particular statute for those crimes allegedly committed during the Capitol riot. And the reason why this is so significant is because former President Trump in that case pending right now in front of Tanya Chutkan. We've talked so much about this morning and in previous broadcasts. Donald Trump is also charged under this same statute in 2 of the 4 counts against him in the indictment there. And that is of significance even as that matter proceeds ultimately to trial once this issue related to immunity is finally resolved, hopefully sooner rather than later, by the United States Supreme Court. Joseph Fisher says, of course, the law has been applied incorrectly against people who were charged over their involvement in the riot. And federal prosecutors, of course, come back against that and say, no, Mr. Fisher was one of thousands who participated in that attack. And the charge that we have brought against him, that is this obstruction charge, is precisely right. Mr. Fisher says no. He says that the law, which was in fact created, he's right about this, in the wake of an accounting scandal in 2002, initially enacted by Congress to prevent corporate malfeasance during trials. He says that government prosecutors and people in the U.S. Attorney's Office, Department of Justice generally, have been unreasonably stretching this particular statute to apply to these charges against him and about 300 other people. The lawyers for Mr. Fisher, who've been defending him in the lower court, in the circuit court, and now the Supreme Court, said specifically that those who stormed the Capitol on January 6th were not acting corruptly. That's the important language from this particular statute. That's what the law commands, the demands under this particular statute. They said the rioters were protesting what they honestly believed to be a stolen election, not acting corruptly. Justice Department, of course, pushes back strongly against that, has argued that the official proceeding could refer to a proceeding of Congress, and indeed that all the terms and conditions, all the elements of proof are there with respect to this prosecution against Mr. Fisher and about 300 other people also charged under this same count, this same statute. The Supreme Court decision to hear the matter then is significant not only for Mr. Fisher and, frankly, huge numbers of people already charged under that particular statute, but also for, yes, that's right, criminal defendant Donald Trump now facing prosecution on that indictment against him in Tanya Chutkan's courtroom. We know well that the special counsel charged Donald Trump with obstruction of an official proceeding, along with 3 other federal crimes. They used that particular statute. Donald Trump, we hasten always to add, has pleaded not guilty. He is entitled to the presumption of innocence and is entitled, if he cares to, not obliged to present evidence in defense of those charges against him. That's what a trial is all about. That's the due process in our nation about which he complains. Instead, he says, I'm a victim of a political witch hunt. As we've talked previously, nothing of the case. The attorneys for Mr. Fisher in this collateral but very much related case noted the connection between their petition with respect to their client and Donald Trump. He said the case presents an important question of federal law affecting hundreds of prosecutions arising from January 6th, including the prosecution of former President Donald Trump. And here's the rub. Here's the reason why this is so significant. When Joseph Fisher first presented this to the lower court, again, one of Tanya Chutkan's colleagues, the trial court in the D.C. trial court there, the district court actually ruled in favor of Mr. Fisher and found that indeed the government was wrong and that the attorneys for Mr. Fisher were right, that this particular statute does not apply to him, and therefore entered an order that basically would have reversed the judgment against him because it was improperly charged. Interesting, the wake of that goes up where? To the D.C. Court of Appeals, the same kind of process we talked about before in connection with the matter related to immunity. And the D.C. Court of Appeals, a 3-judge panel there, decides not unanimously, but by 2-1, to overturn, to reverse the lower court ruling and basically say, yes, the government wins. The government has, in fact, properly charged this particular case against Mr. Fisher under this statute and reverses the trial court decision. And it is that appellate court decision coming out of the D.C. Court of Appeals that is now before the Supreme Court. That's the decision that the Supreme Court has granted certiorari on, and that's the opinion, that's the judgment that is now up for their review by all justices of the Supreme Court. And as indicated by the differences in opinions by reasonable people, the appellate court, the lower court, This is one where reasonable justices, reasonable lawyers, reasonable people, non-lawyers can disagree, as we often say. Mr. Fisher asking the Supreme Court to basically endorse what the trial court had said, to reverse what the appeals court had said. And indeed, there are arguments on both sides. It is not unusual, candidly, for the Supreme Court during the course of my time, my 30 years with the U.S. Department of Justice as a criminal prosecutor and also civil litigator, including some years as the United States Attorney, some years in Washington, D.C., some years overseas in another district in this nation. All during that time, the Supreme Court has from time to time taken statutes and said, you know what? The government has not been properly applying them. I think especially about the mail fraud statute, having to do with the possibility of prosecuting public officials for the deprivation of honest services. It's a broad and important discussion having to do with the interpretation of federal law. The Supreme Court overturned the commonplace application of a particular statute and said overnight and changed overnight the disposition of cases pending in the federal trial courts and the appellate courts. Supreme Court can, in fact, interpret this particular statute that Mr. Fisher is challenging to say that, you know what, the government got it wrong. They could also say the government got it right, in which case Mr. Fisher's judgment and that of the 300 other people remains in place. Those convictions go forward. The terms of imprisonment, to the extent that those sentences have been imposed, those go forward, and those cases get closed. And then, significantly, Jack Smith, in his prosecution against Donald Trump, after the Supreme Court resolves this immunity issue, can go ahead with all 4 counts of the indictment against him, depending upon what the Supreme Court says. Supreme Court could make some decisions that parse the language somewhat and determines that, in fact, it is applicable here and not there. We'll have to wait to see exactly what they do, and that's the final point in the Fisher matter. Again, having to do with timing. As of this morning, February 10th of 2024, the Supreme Court still has not granted a date for oral argument on Fisher. It's got a docket now through the end of March. Its March setting is chock full of cases. We talked about some of those last broadcast. To this date, to this morning, the Supreme Court has not put Fisher on its docket for oral argument like it has, presumably has, in these other cases. And what that means is that this case may not be heard until April, maybe even May. At that point, it gets very, very late in the season. We certainly would anticipate that the Supreme Court will decide Fisher by June. But if indeed the timing on this is such that the Supreme Court, hopefully, would embrace the notion advanced by the government. That certainly is my bias, but again, my reading of the statute, my application of it, my understanding of how Jack Smith is using it to the particular facts against not only the Fishers of the world, but yes, also Donald Trump in that indictment. We talked about that indictment at great length in prior broadcasts. Strikes me as a former prosecutor that its application here, although not routine, is appropriate. And the Supreme Court should indeed embrace that application as it has in other cases. If, in fact, it doesn't do that and basically stops the judgments and the convictions from going ahead with respect to Mr. Fisher, it presumably would also have an impact upon the trial in front of Judge Chutkan, wherever that may be in April or May and June. And once again, underscoring this common theme that I continue to repeat, which is timing, and how all of these decisions will have an interplay into the very trials that are being affected by decisions of higher courts. If Mr. Fisher is successful, the prosecution by Jack Smith against Donald Trump potentially could be cut in half or significantly changed. The government can always go back and supersede, return a new indictment. But again, getting very late in the day, again, in the midst of an election year, as Donald Trump presumably is collecting primary victories along the way, as the current president, Joe Biden, is also collecting his primary victories, heading toward nomination in July and August, heading toward an almost certain battle between Donald Trump and Joe Biden in November. Depending upon how the courts decide all these cases, and today I'm not making any specific prediction about Fisher. I believe that there's a strong, strong argument to be made that the government is right about this. And I anticipate the Supreme Court, at least a majority of them, will embrace that. Probably won't be a majority opinion, but a majority of them will embrace that. Depending upon when they decide that case, however, once again could have an impact upon the conduct, the timing of the trial, the timing of a presumed possible conviction by a jury based upon the evidence presented. The government, once again, obliged to present evidence beyond a reasonable doubt to a jury, has to decide it unanimously. All that's got to happen before there could be a finding of conviction, a finding of criminal liability, before the assumption of innocence, the presumption of innocence, no longer applies. Lots and lots of things going on. A win for Donald Trump, almost certainly with respect to Colorado. A loss for him coming up with respect to immunity. The question there is, when does that happen? And then presumably a loss for him as well when it comes to this Fisher case, but not nearly as certain. And the timing on that, probably of the three, the least certain of all. I should note as a footnote to that among the other cases that we will also discuss in future broadcasts, on the same day that the United States Supreme Court granted this writ of certiorari in the Fisher matter, they also granted the writ of certiorari reviewing the decision that you may recall well coming out of Texas and the Fifth Circuit. This decision made by Matthew Kaczmarek, a district court judge in Texas, banning the distribution of mifepristone, which is this commonly used abortion pill, and determining that the FDA had improperly authorized its use by medical officials, by doctors, and by other medical staff around the country. A shocking decision, recently also further undermined by revelations that the very laws and the very findings that he came to premised upon some official findings, if you will, some science that's determined to be junk science. Just this past week on that particular case, the decision that Judge Kaczmarek came to premised upon his view that mifepristone is in fact dangerous, is not in fact the safe and secure drug that the FDA has said it is. Just this past week, the authorities, who are a thing called Sage Publications, announced it was retracting 3 of those articles that helped form the basis for Judge Kaczmarek's conclusion that access to this drug, mifepristone, should be restricted. Now, that's somewhat of a sideshow to the appellate issue, which went up to the Court of Appeals and is now before the Supreme Court. And they also will be entertaining argument on whether or not mifepristone remains an accessible medical procedure, a medical pharmaceutical for abortion practices in America. That also coming up. They granted that writ on the same day that they granted the writ in the Fisher case, which we will talk about as well as those cases are decided down the road. Lots and lots of things pending before the United States Supreme Court. More to talk about this morning on our broadcast, including some commentary related to the prosecution in Georgia and the recent decision by the special counsel reviewing the Joe Biden documents case not to prosecute. All of that coming up next.
Media.us.
You're listening to The Shaw, WAUK.
Our website, civicmedia.us.
This is our final segment of our Saturday morning broadcast, talking about 3 more cases that animate what's going on in our federal courts. We spoke before about Eileen Cannon right now presiding over this unrelated but somewhat associated trial having to do with the Mar-a-Lago documents just this past week, making some significant decisions about witness security. We know from recent reporting that federal authorities right now are investigating a series of threats made online to potential witnesses related to this Jack Smith prosecution of the classified document case. And that had prompted Jack Smith to seek the disclosure to the court and to the litigation generally of information relevant to that prosecution, but not in the public domain, ensuring that Donald Trump and other people do not have the opportunity to provide information about these matters that are security related, that have to do with the integrity of the process and that expose potential witnesses to threats of harm. This past week, Jack Smith is asking Eileen Cannon to reverse a recent decision that could expose potential witnesses in that case to threats from the very thing that these investigators are looking at right now. Special counsel filed a motion to reconsider that ruling, which they considered a clear error that defied 11th Circuit Court of Appeals precedent, and that would publicly release discovery documents in unredacted form at the request of the former president and some media groups. Again, Jack Smith trying to protect the integrity of the process and the witnesses there. Special counsel's office pleading with Cannon to reverse that recent unsealing decision, which would disclose this information about those witnesses that would identify 24 of them and expose them to threats. And in particular, the special counsel saying the discovery material publicly docketed in unredacted form would disclose the identities of numerous potential witnesses, along with the substance of the statements they made to the FBI or the grand jury, exposing them to significant and immediate risks of threats, intimidation, and harassments, as has already happened to witnesses, law enforcement agents, judicial officers, and Department of Justice employees whose identities have been disclosed in cases in which defendant Trump is involved. Now, why is this significant? Well, it has to do once again with Eileen Cannon and the 11th Circuit. Smith in particular arguing that the judge incorrectly stated that the government must show a compelling interest in keeping the documents private. That is not the standard. That isn't the standard that's used by trial court judges. And Jack Smith, of course, adopting that and saying the standard does not apply to documents filed to satisfy discovery requirements, saying just this. The 11th Circuit has held that the compelling interest standard applied by Eileen Cannon does not apply to documents filed in connection with motions to compel discovery, which instead may be sealed or redacted simply upon showing of good cause. Because the court applied the wrong legal standard, reconsideration is warranted to correct clear error. Now, what does that all mean? That means that Jack Smith is giving Eileen Cannon another opportunity to go back and get it right this time. She has applied the wrong standard. And he has said, before we take this up to the Court of Appeals, before we go back to the 11th Circuit, we'll give you the chance to remedy the error that you have made. Now, unlikely that Eileen Cannon will do that, in which case, predictably, because of the seriousness of this, we've got people's lives that are at stake, threats made against witnesses and other officials, highly likely that Jack Smith will take this up to the 11th Circuit. Have we seen this show before? The answer is yes, we have. You may recall well that in the wake of the search of Donald Trump's Mar-a-Lago residence, Eileen Cannon entertained for months a challenge to the investigation, pre-charging before any charges were returned, ultimately taken up to the 11th Circuit. And you may recall well, the 11th Circuit sends this compelling order back to Eileen Cannon saying, you've got it wrong. The trial courts have no business involved in these kinds of investigative matters. You've got no capacity to oversee this investigation. Do you have responsibilities when it comes to executing search warrants and doing other things, applications for discovery during the investigation, but not oversight in a civil setting of the pendency of a criminal investigation like this one. 11th Circuit sending that back with a firebrand on top of the order saying, dismiss this case, which you have entertained, Eileen Cannon, you've gotten it wrong. Jack Smith now probably will take this up again, and we may see a repeat of what happened before. And at some point beyond this, also, Jack Smith may well finally file the application for recusal, for substitution of a judge, because of the record of, let's call it hostility, that he is beginning to amass in this case. We know as well that she has made various orders, delayed certain proceedings having to do with the legitimacy of certain national security matters, how that is processed, all those things being delayed. Jack Smith has a list now of things that Eileen Cannon has done, both in terms of delays and now affecting the future of witness presentations that go right to the core of this criminal prosecution. And in addition to going up to the Court of Appeals, where he presumably will get the Court of Appeals to embrace the proper standard, and the Court of Appeals will presumably send this back to her and say, you've got to apply the proper standard. You've got to reverse your previous order. All of that, once again, taking, here we go, time, right? Tick-tock once again. But even if that happens, Jack Smith at some point needs to consider, as I'm certain he is, inside the halls of justice there in Washington, D.C., a potential petition to have her recused based upon the conduct in which she's engaged on the bench, admittedly in her official capacity, that can indeed affect the legitimacy. This is a big one, having to do with whether or not the disclosure of names, identities of witnesses that we know have been the subject of threats and concerns about the future of their presentations in trial, that nothing short of that is at stake in this matter. It's a huge issue. It's a huge issue. And finally, just a couple of very brief comments. One is with respect to the Joe Biden release from the special counsel, finding that indeed he should not be prosecuted because indeed there's no willfulness. I want to say that I concur with my former boss, Eric Holder, who said that the comments about the status, the condition, the temperament, if you will, the intellectual capacity of the present president during the course of his interview, completely inconsistent with internal Department of Justice processes and language. And when I was in the Department of Justice, that kind of thing would be reviewed and would be excised because it's not relevant to the core finding, which is about willfulness, which is what that report said. And the extraneous language about the president, it's not just a political comment. It's not a political comment at all. It's not properly there. It's not properly there. And it is unfortunate that in the midst of this otherwise legitimate review and exercise of investigative prerogative by the special counsel there, that the determination, a proper determination of no criminal prosecution based upon a lack of willfulness, is joined with this harassing and inappropriate comments about one of the witnesses, the target, the subject of that investigation. More of this kind of discussion in all of our Saturday morning broadcasts coming up. I invite you back to our table in the future discussions of the